Okay, so first of all, can I just get a general consensus? Has everyone read the fact pattern thus far? You can just, okay. Some of you skimmed it, some no. Okay, so you haven't read it in depth yet. That's fine, as long as you're familiar with, what it is, what the issues are. So the issues in this specific competition are refugee law, data protection law, sovereignty, as well as, what was the other one? And reservation law. Yes, that's really wild of me to have written the entire thing and not remember the issues off the top of my head. But those are the main issues of law that you'll be discussing in this competition. As some of you may or may not know, there are two components of a moot competition, the written part as well as the oral advocacy. For the last few MOOC competitions that we would have had in the past, we would not have had students write two memorials. So there's the applicant, there's the respondent. For our competitions with Monocampus, we just had the students write a memorial for one side. However, typically in many bigger international competitions, you have to write memorials for both sides, and they have to be very well done. Usually a memorial is, let's say, 30 pages. I would say a typical memorial for the Jessup competition, which is like a year long, well, not a year, like 8 months. It's a competition that runs for like 8 months every year. You would write a memorial that's about that. You would write two memorials that length, one for the respondent, one for the applicant. And so you'll have to do that for this one as well. Obviously, we're not expecting you to write 30-page memorials. The fact pattern is only, I believe, 8 pages. So, maybe you might have like a 12-page memorial, something around there. So don't worry too much about covering everything. Also, it is up to you guys to decide whether or not you want to sign up alone, with a partner, with 2 partners, with 3 partners. The maximum amount of people that can be in a team are 4 people. So if you're signing up with 4 people, 2 of you will have to be advocates and 2 of you will have to be researchers. You'll have to take on the role of researchers. If you are signing up as 4 people, only 2 of you will be able to actually participate in the oral advocacy portion of the competition. So if you are interested in actually doing the oral advocacy part, I would only advise that you either sign up by yourself or with one other partner. In terms of the prize, the ultimate prize for the winner is a gift certificate to Gurley and Associates Book Specialist. That's a bookstore that has all the different law textbooks for $1,000. The winning team gets $1,000, and $1,000 certificate. If you're signing up as 2 people, then each person gets a $500 certificate. If you're signing up as 4 people, you will each get a $250 certificate if you win. So is that clear so far on how the prize is allocated and what rules are taken on? Okay, great. So I don't know if maybe that information changes whether or not you want to sign up with 4 people, if you want to probably go for the $500 prize rather than a $250 prize. It's totally up to you guys. Yes, it is for the experience, and I believe there's also a trophy where you will have your names engraved. So if you are doing a team of 4 people, although you have to, kind of take a bit of a lesser prize, you do also get the extra help on the memorial part. So for me, I was in a team of 4 when I did the Jessup competition. That meant that although 2 of us were researchers and 2 of us were advocates, all 4 of us worked on the memorial. If you're an advocate, I think that you definitely should be working on the memorial regardless. You need to be familiar with the law, you need to do the research and what have you. But 2 of us did a memorial for an applicant, 2 of us did a memorial for the respondent. And we would kind of work together like that. And so when I was done with my applicant memorial, for the first 2 grounds, so we had 4 grounds, I would do the first 2 grounds for the applicant. My partner would do the last 2 grounds for the applicant, and then our teammates would do the same thing for the respondent. And I would trade my my part of the memorial for with the teammate who's doing the respondent side on those first 2 grounds, and we would give each other feedback, because obviously he would have known the specific points against my applicant because he's doing it for the respondent. So he could show me where I'm being weak, and I can do the same for him. And that's how we worked with the team of 4. You can also sign up as a team of 3 if that's what you wish. But if you do sign up as a team of 3, then you will obviously have a bit more of a workload. For the CCJ moot, we had a team of 3 where, however, they only did they were only supposed to do 1 memorial, but they ended up doing a memorial for each side. But they did split up the work. The 2 advocates worked on it. And the 3rd person was played the role of the researcher, and he would assist both of them. And that's how that went. And if you choose to do 3, if you choose to sign up with only 2 people, then maybe it might be best for you to do for one of you to do the memorial for the respondent, one of you to do the memorial for the applicant. But it's up to you. Maybe you want to do both grounds for both of the first 2 grounds, and both the respondent and applicant, and your partner wants to do the last 2 grounds for each, the respondent and applicant. You can choose to work that way as well. Again, it's totally up to you. If you sign up alone, you will be matched with someone. You can't do this alone. So, that's something to consider. And while, you won't really have control over who you're matched with. Of course, if you do have issues with the person that you're matched with, you can reach out to me or Dr. Peru, and we can handle it from there. But that's all you need to know in terms of the teams and the dynamics. Is everyone all clear on that so far? Do you have any questions? Okay. Sasha has us. Okay, great. So you're all good on that. So while I've explained that, I want you all to digest that. And while you're digesting that, I think that it would be a great, it's a great time to hear from Nicholas. He was, as I said before, he competed in the CCJ moot, and I asked him to come here and tell you all a little bit about his experience and what mooting really entails. So Nicholas, are you ready?
Hello, good afternoon, everyone. It says I can't start my video. Huh, interesting. Let me rejoin quick and
Sure.
see if that can help.
Okay. But in the meantime, some other information I can offer you is, aside from the sessions, the other 2 sessions that we're gonna have, you all will also have advisors throughout your team. throughout the duration of the competition. So we're going to assign you advisors for the memorial portion. You will be able to reach out to your team advisor for feedback if you want to give them, if you want to, let them, if you want to run your ideas by them and see what they say, if what you're saying makes sense, you can, that person will be there to guide you through that. And then for the oral advocacy part, you are going to have another set of advisors. It may be the same advisor, it may be a different person. I don't know yet. But you will have that opportunity to be guided. However, for the oral advocacy part, each team, will only have 2 sessions with their advisor. So you'll only be able to practice with your advisor 2 times. And that is, and when I say practice, I mean you'll only have an opportunity to make your submissions, say what you have to say, and have them judge you as if you were in the competition on 2 occasions only for each team. The reason why we did this is because we don't want for certain teams to have maybe an advisor that's a little less busy, and then they're able to dedicate more time to their team, and then we have an advisor that is extremely busy and may not be able to dedicate as much time. That would be unfair. So we're limiting it to 2 sessions only. So when it is that you're ready to practice with your advisor, make sure that you are ready, and that you know everything that you want to say. So my advice would be practice amongst yourselves first before you practice with your advisor. But Nicholas, I think you're ready now. Okay, great.
Hello, good afternoon. Just confirming that all of you can see and hear me.
Yes.
All right. All right, good. Glad to hear it. Seeing affirmation in the chat. All right. Well then, good afternoon, everyone. Oh, sorry, good morning, everyone. My name is Nicholas. For those of you who may not know, I was I don't know if I should say was, but final year student at the faculty here. And I did participate in mooting, unfortunately, not from the course as Alex would have done, but within the various competitions, or thank you, Eniko, within the various competitions as they would have arisen through my final year. So that's when I really started to get involved with mooting. Some of you here, I think you may be going into second and final year, so there'd be a mix of you. But mooting for me was a tremendous experience. Like, I can't understate, like, I can't exaggerate really how much it impacted me in terms of my confidence and my levels of preparation going into this oral advocacy experience. But let me start from the beginning, really. So mooting for me started with the internal competition as you guys are doing, or as you guys are contemplating right now. So I would have learned from Alex, who was a wonderful teacher, I must say. She taught me and my fellow competitors all the ropes, showed us all the manners and forms with which we were expected to go into the court, and just the level of preparation and the various sources of law that we were also supposed to use with this. So mooting, especially in this internal moot competition, largely tackles topics of public international law. And me, I'm kind of scared that this is being recorded, but me, I can tell you all that I really did not pay much attention at all in Pill 1. Like, Pill 1 was just not one of my favorite courses. It was not very thrilling or exciting, and I just wasn't there for it, really. But when I finally got into it via mooting is when I really started to see what the intricacies and the intrigues of a public international law with regard to how you're supposed to present yourself before a court. And that's the thing about mooting, is that it shows you how to present yourself, how to be an oral advocate in front of a court, and it's very low stakes. The main thing about that you learn from mooting is managing your nerves, I would say, which is, come on, obviously. And then it's a very low stakes environment because there's no serious consequences if you lose a moot. Like if you don't want your first preparation to be before an actual court. You know, where you have a client who's expecting things of you, or you may have superiors depending on if you're in a law firm or not. But mooting just gives you the opportunity in a very low pressure environment, high pressure that you're placing on yourself, no doubt, but objectively, a low pressure environment that's in a competitive sense still, so that you still get the adversarial approach that you'd want from a law dispute, and it gives you that opportunity now to really distinguish yourself before the court. But back to my experience, uh, the internal moot that we would have gone through broached on many different topics, such as the use of force in public international law, treading on the general prohibition within the Charter of the United Nations. Again, refugees, as Alex put in this moot fact pattern, as well as reservations again. But, 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 like I said, I didn't know pill one. So when you get to reading a moot fact pattern and you don't know anything at all, that is the beauty of mooting, because it shows you that despite not knowing anything, which is completely normal, at the first turn of the page, you'll get to a point eventually where you'll be able to speak on this for minutes at a time, where you'll be able to cite authorities that you didn't even know you would have encountered, or that you would have memorized, and sounding like an actual lawyer before the panel of judges that they put to judge you. And the thing is that it's such a gratifying, it's such a satisfying experience to be able to put on that air of a lawyer, and to speak as if you were an actual attorney addressing the International Court of Justice or whatever relevant panel it is. And you're able to speak with that kind of confidence, knowing that you have put a lot of preparation into your memorial, that you'd have spent potentially hours upon hours in practice with your fellow teammates and with your team advisor. And all that preparation going into the moot finally it finally allows you to just speak with the utmost authority on the relevant field. So that was the internal moot competition, and thankfully, me and my partner Nico were able to win it. And that alone was a very grueling process of many days of competition as well, leading up to the finale and the finals, which I'll be honest, I wasn't really proud of my own performance, which is another thing in mooting as well. Don't feel too bad about having one bad moot, because every single bad moot that you have, every single moot in general, every session, every actual day of competition is going to be very instructive to you moving forward. It's public speaking expertise. You're going to learn more. Even if you're coming from a place of not knowing anything at all, you're going to learn. The same way that you prepare your memorial, it's the same way that you learn the mannerisms of the court. It's the same way that you learn just general argumentative techniques that can propel you forward. So that after that internal moot competition, which I said I was feeling pretty low on, even though we were able to win, I knew I didn't give the best performance that I could have. I used that to motivate me for the CCJ moot, the moot of the Caribbean Court of Justice, which is a lot more specialized. It's in a lot more specialized area of international law than what we covered in the internal moot competition. So the CCJ moot deals with the law of the original jurisdiction of the Caribbean Court of Justice, which involves the law of international trade. which is a course that you could even do in the third year of your LLB, but still, the CCJ moot requires a lot out of you in terms of preparation that you wouldn't even really see in the international law moots like at JESUP or in the internal moot competition itself, because again, those are general topics of public international law. But when you get to these specialized tournaments, now it's another level that's really being built upon it. Like you're carrying yourself forward into again a situation where you look at the fact pattern and you don't know anything at all. Like you're just reading pages upon pages of text and you don't really know anything, and then you start to get into the research, you start to get into the treaty interpretation, you start to get into the preparatory documents, you start to get into the case law, especially, which is so relevant when you're doing international mooting. And then you start to finally see, all right, well, here are the arguments that I can build, and here are the sources that I can pull that would really propel my argument forward, that would make it stronger. And if when you're mooting, that's so important that you have the proper sources around you, because mooting isn't just speaking at length spontaneously on a bunch of different topics like what I'm doing right now. Mooting is coming into it with a level of knowledge of the background field and all the writings and all the relevant case law. Not that you have to know all of it, but still, it definitely helps to know all of it. That you have all this wealth of knowledge behind you, and that you're able to pull and collate your sources in a way that supports your argument, in a way that's relevant to your memorial, and in a way that would be able to persuade the judges that your argument ultimately is the correct argument that should be pursued by the court. So that when you get to this level of preparation now in the CCJ moot or other specialized mooting competitions, you're going into these very fine areas of international law, fine areas of law in particular that would be somewhat controversial or not fully litigated. And when you're able to bring these novel arguments again, because it's a low stakes environment, you're able to appreciate all the nuance within those topics, within those various branches of the law, and uh, you're able to come out of it with a lot more valuable experience than just learning a course and learning all the material by rote for an exam or for your coursework or whatever. So that was my experience with the internal moot and with the CCJ moot. The CCJ moot in particular was very rewarding, I'd say. I mean, give us little participation tokens, even though, again, well, me and Aniko weren't able to win ultimately. We were still able to learn a lot in terms of just general things like how to pull our sources together, how to speak before the panel, how to well just in general, like learning more about specialized areas of law or international law as the case may be. And all that helps in terms of just building you as a holistic student. But it helps because it's not just, like I said, it's not just sitting down in a class and just learning everything there, just listening to a lecturer. Mooting is a very self-taught field. Again, you'll have your advisors, so you're not doing it alone. You'll have your advisors and you'll have your teammates, so you're not doing it alone. But you have the assistants there, and you have your own heart to guide you as to how to really distinguish yourself. I'm saying distinguish too much, but anyway, how to really how to carry yourself out in a dignified manner. Let me put it like that. So that was just my experience in the broadest strokes possible about mooting. Um, I now see the chat love the flex. No, I mean, it's a nice little medal though. They even gave me a certificate here. This is a flex. They got bet up by TT Post, but regardless, it looks nice though. Anyway. Yeah, that's mooting in a shell nut. Big up star, of course, of course, of course. If you guys have any particular questions that you might want to ask, because I didn't really go into the particular grants of working through a memorial or like specific things about oral advocacy that you might want to know about. But I mean, I am here if you want to ask any questions about it. Yes, I shall not. But yeah, that kind of wraps up what I wanted to speak about today. That was my experience with mooting.
Sasha, you can go ahead and ask your question.
Hi, Nicholas.
Yeah.
Okay.
Aaron,
So, you said that these areas of law are obviously very fine, and they all fall within. Well, I believe I know refugee law for sure falls within the remit of public international law. How do we start? Because public international law is so wide. Like the book alone, and this is general. The general book is like what 800-900 pages, and I have it in front of me. It's heavy. Um, how do we go about starting to find these things? Because it's a very daunting task, especially for me, to find maybe this one minute detail of a case that 4 or 5 other law publications didn't post this one small detail that could make a difference when you're making your presentations. So I just want to know, how do we start? How do we start going about searching for these different little minutia and areas of law that are big within themselves?
all right, that's a brilliant question. Always, like I said, mooting is arguments with relevant sources before you. Always be guided by Article 30. Well, I can't even remember the specific thing. Article 38(1) of the Statute of the ICJ, I believe, listing out the relevant sources of international law. That is, of course, treaty law, principles of customary international law, general principles of law recognized by civilized nations, as well as statements of law, secondary statements of law in case law, as well as general scholarly opinion. So the starting point for that, I would say, the starting point for any moot, I would say, is reading the treaties, acquainting yourself with the provisions of the treaties themselves, because those are the broadest areas that you're going with. Because what you're ultimately referring to at the end of the day is that your particular client in the state of whoever has not breached an international obligation, or that some offending state has breached an international obligation under a particular treaty. So you want to be very clear about what exactly that treaty obligation states within the text of the treaty. But as you know from your class on public international law, or as you might not know, as I didn't, you are supposed to interpret treaties according to the Vienna Convention on the Law of Treaties in light of the object and purpose. And how do you find that object and purpose? You can source it in the preamble, of course, and then it's also demonstrated through the case law. Now, you wouldn't know the case law right off the bat, but you have the relevant areas within the textbook. If they have that, when you see like those general broad strokes in the textbook, well then, like Harris, for example, can give you a wealth of information on particular cases. But what me and Aniko found like the most helpful, of course, is just going through journal articles. You go on UWE or you go on Google Scholar, you go on Westlaw, and you just search up how, yeah, well, I mean, we don't really use PDFs, I mean, of course, but still, anyway, you look at the relevant journal articles and they're able to point you to those minutiae, they're able to point you to the fine points, the fine areas of case law or general customary practice that have shown like these areas that you may be able to pick up on and use in your arguments for the moot. So statements here by a judge in one particular case. Again, you don't have, it helps to read the cases, obviously, but reading the articles can also point you to the most illuminating factors in each case, and as well those factors that you might not have even picked up on if you had just jumped into the case one time. So scholarly opinions first, I would say. All right, sorry. Treaty first, followed by scholarly opinions, and then those scholarly opinions can point you to particular areas in the case law or within customary international law that you can focus on.
If I can just add as well, Nicholas, I'm not sure if all of you know yet, but I wrote the fact pattern. And one thing that I will say is that I wrote it in a very deliberate manner, which is to say that, I haven't put anything that is extremely niche in terms of international law. And again, I'm not going to go into too much detail. The probably most novel aspect is the data protection, but there is a wealth of content on data protection regulations. That is to say, while yes, researching the actual law is very important, I think that one of the, well, probably the second starting point might be to go through your facts, because in the way that I've written this, you are going to rely heavily on certain factual details to make your case. So I think that that's something that you should also consider as you build your arguments. One thing that I've done with every moot team, well, almost every moot team that I've ever coached, is we sit down, we go through the entire fact pattern, we we highlight the things that we think that maybe this is something, maybe we can use this. That's something that I definitely recommend. I did it when I first did mooting, and it was very, very helpful. Sometimes I think a lot of students tend to focus on just the last page where it states what the issues are. But you are meant to engage with the facts very much. You can't just come and say, oh, well, article this of this convention says that you have to do this. It's not as simple as that. You do need to figure out how this certain provision is applicable in this instance. Sometimes it's not always applicable. So fully endorse what Nicholas said, but also do make sure that you're very cognizant of the facts. Do we have any more questions? Sasha, your hand is up. Do you want to ask another question?
No, I'm good right now. I'll put them on.
Okay. Do we have any other questions? You can drop it in the chat. You can put it in. You can put your hand up. But in the meantime, while you all think of any questions you may or may not want to ask, I will talk a little bit about the whole aspect of anxiety, because actually Ronaldo asked in the chat tips for overcoming anxiety during oral advocacy. So Nicholas, why don't you take that one?
All right, well, I see Dylan asked a question too, but I'll stick with I'll stick with Ronaldo's question for now. Like Nico said, that's a beautiful way to say it, really. Fake it till you make it, but no, honestly, you're going to feel nerves. You're going like, because it's pressure, it's internal pressure, it's pressure that you're putting on yourself. You want to make sure that you don't go out and embarrass yourself in front of the judges, or you're going to be scared that the judges are going to ask you hard questions, things you don't know. Again, preparation, preparation, preparation. Cannot stress it enough. It is so important, because you want to preempt what the judges are going to ask. You need to know your entire memorial, like the back of your hand, really. And you need to have it like so familiar to you that you need to know its drawbacks as well. You need to know the shortcomings within your memorial, because that's the main thing you're going to be scared of when you're doing a moot. Well, either that or that you forget your points. But I mean, honestly, there's so many ways around that. Of course, you have, you could have like separate notes. You can have like a page that you memorize of just like the key. One of the key things that Alex went through with me is just like mapping out in bullet points the things that you want to, the things that are absolutely essential that you have to talk about. And then in between those bullet points, all the rest of the knowledge will just like flow in. Like, all that comes with your practice. And yeah, that between that and preparation is just in terms of nerves, I would say that just make sure that you have like a little calming ritual that might help. Some people, whether that is in terms of like dietary things, like well, make sure and drink a lot of water, make sure you stay hydrated, make sure that you don't moot on an empty stomach, things like that, all those kinds of things. Do things to psych yourself up. It will help. I don't know if Aniko wants to mention anything in particular, but I know that she could probably have Alex. But Nico like has some good advice maybe on like how you can deal with anxiety because um like me personally I'm not really taken too much by anxiety, thankfully. Um like of course like I do still like get like some butterflies, some jitters before the mood, but um it's not really that serious because like the thing I tell myself is that it's not really that deep at the end of the day whether or not I stumble here or there because when you're watching like actual proceedings before a court, it's very normal for lawyers to stumble. Very, very normal for them to have to sift through papers looking for a particular piece of precedent, looking for particular a particular principle or a particular provision that they might have forgotten. So all those things, like you just learn that they're part of the trade, and that if you make a little mistake here, the judges aren't gonna pick up on it unless you let it bother you.
If I could add as, I'm sorry, I see Liana's hand is up, but let me just add first for the anxiety point. I've coached a lot of students for MOOC competitions in the past year and a half. I don't think that there was a MOOC competition that I wasn't involved in, honestly. But there's been lots of students. Some were very naturally brave, some were very naturally soft-spoken and weren't as confident. Mooting is something that you can come into not being confident at all, and you will still be able to succeed because it's a learning process. Even the extroverted students that I've trained, just because you're outspoken and extroverted does not mean that you're going to be good at mooting. It's one thing to be able to speak well and to be able to think on the spot. It's an entirely other thing to be able to substantively hold your own against a judge. And that's something that everyone learns when they're doing mooting. It's what happens when you train. When you're trained, you are very well trained to be able to handle that. So I wouldn't say that that's something that you need to be extremely wary of. But it is good to know like whether or not you are comfortable going into it so that you can let your advisor know like off the bat. For me, I would much prefer if a student comes to me and says, listen, I'm not an outspoken person. I'm not an extrovert. I've never done public speaking before. That then makes it easier on me because I can adjust my coaching style and know how to cater for you properly. So and just one last thing as well. Every soft-spoken student that I've coached, there's never been one that hasn't done exceptionally well. Aniko, as she gave me permission to share her story, she said that she also struggled with the anxiety of it all at the beginning, and having trained her for 2 different competitions, she has shown exponential growth from where she started to where she is now. That's not to say that she's an extrovert now. She's not, and people are the way they are. If you're an introvert, you're an introvert. If you're an extrovert, you're an extrovert. That doesn't mean that you can't speak well, because she can speak really, really well now. And she's more confident when she speaks as well. It's still something that she has to deal with, but it's something that she now knows how to cope with better. And Mutsun has helped her do that. It's also helped her to feel a lot more comfortable. I, on the other hand, as a natural extrovert, I was naturally outspoken. I still wasn't good at mooting when I first did it. I think for the first practice session I ever had, I could only answer one question in like 15 minutes of practice. So I think that one notion that we kind of need to divorce ourselves from going into this is that this is you're not going to be naturally advantaged or disadvantaged based on whether or not you're an extrovert or introvert. It's a learning process, and everyone starts off with a clean slate. Liana, you can ask your question now.
Hey, morning. So I think you already touched on my question about judges, but in particular, I wanted to hear a little bit more about the difference between mooting in front of a hot bench and a cool bench.
Nicholas, you want to take that one?
Mooting in front of a cold bench is like so anxiety inducing, I swear. Like, especially in a virtual moot, you're wondering like so many different things, like so many different thoughts could be like swirling through your head. Are they, is my connection dropping? Is my mic not working?
No, it's
all these
working.
things-
It's working.
No. I'm talking about like when you have a cold bench
Sorry.
and it is just like so quiet. Because the thing is, when you're mooting, you want to like at least have some kind of visual feedback. You want to have like some kind of auditory feedback. Like you want to know that the judges are hearing what you're saying and that they're intrigued. And that's the thing with a hot bench. At least you know that you have their attention. With a hot bench, it's a lot more disruptive, naturally. But if you're able to still answer everything, like even when you have a hot bench, you're still able to go through your memorial. Like I saw Dylan asked in the question to in the chat as well. What's it like having to think fast on the spot when being questioned by the judges? So that's those two of them kind of go hand in hand together. So I'll touch on Dylan's in the meantime, because when you're being questioned and just like back to back to back, like you have a hot bench and they're just not letting up, everything that you would have learned from in your readings, in your own independent readings, or with your group, you use that because you're not able to pool everything together in your memorial. Your memorial will have a specific word count. So there's arguments that you might have to abandon. There's particular sources that you can't include. There's particular footnotes that you can't even fit in just because of the word count. Well, yeah, that's the worst case scenario. But anyway, like that's another thing. Yeah, there's particular like footnotes even that you can't even include. So when you have a lot of questions coming at you, rely on those. Recognize that you have 1,000,001 sources that you would have had in the bank. Use those. Again, you can use your memorial as well. Sometimes judges ask you questions just to derail you. They'll ask a question based on something that another area of your memorial can answer. So you need to be able to shift in your submissions to say, all right, well, Your Excellency, that actually carries me to my second submission, which is da 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 da, and you're able to proceed like that. So those are the kinds of privileges that you have when you have a hot bench, because you're able to jump back and forth between your submissions and you're able to talk around the judge's questions in a way that still tackles everything contained in your memorial. When you have a cold bench, you just finish your memorial, you finish all your submissions in your memorial, and you're just wondering, what do I talk about now? Like, it's just like, it's a psychological thing. It's a psychological tactic that they're actually trying against you. Same thing with a hot bench. Like the hot benches are also like psychological tactics just to throw you off. It's to make you go blank, actually, Dylan. Like it's just to overpressure you and just have you melt down. But of course, judges aren't going to be so harsh that they're just going to bully you. Let me not say that. Some judges actually would. But most judges are kind of considerate people. They don't want to just see you cry in front of a moot. So yeah, when you have a cool bench, you just proceed, you do everything, and don't let it get to you. Same thing with a hot bench. You answer all of their questions using all of the sources, using your memorial, shifting between your submissions where necessary, and you get it done.
Liana, is that an old hand or a new question?
Yeah, also, I was wondering if you had anything to add with that, Alex, and I had a second question. So did you have anything to add?
Can you repeat your question once more?
Sure. So what is the difference basically between a hot bench and a cold bench?
Okay, right. So yeah, I endorse everything that Nicholas said. One thing that I would add though is I think that a lot of people think that with cold benches, you run out of things to say. Now that isn't something that's inherent of a cold bench. If you're extra prepared, if you're like well prepared, you will never run out of things to say. It's usually with the hot bench that you find trouble being able to fit everything you wanted to say in. But you know, if you've done all the research that you need to do, then a cold bench is probably one of the gifts of mooting that you'll get because you have that opportunity to say everything you want. That being said, some people like to interact with the judges and kind of rabs them, for lack of a better term. It's fun. I enjoy it personally. I like being challenged and being able to confidently answer back in a professional manner, of course. It is thrilling, exhilarating, and it's a rush of adrenaline. That being said, I don't think that like getting a either a hot bench or a cold bench should be taken as an indication that you're doing badly. If judges are asking you a lot of questions, it doesn't necessarily mean that what you're saying isn't making sense. It's actually quite the opposite. The judges might be really intrigued and they kind of want to push you. Sometimes judges will repeatedly ask you a question because they're pushing you into a certain direction. They want you to discuss something that you haven't yet mentioned. And it's up to you to be able to kind of ascertain what they want you to talk about and be able to seamlessly pivot your submissions to that point. Alternatively, if you get a cold bench, it's not that judges are necessarily bored and turned off to what you're saying. Sometimes what you're saying makes so much sense that they can't actually find a hole in what you're saying. And so they just have to sit back and listen to what you say. So that being said, there's the obvious differences, but I guess what I'm saying is that I wouldn't say that one is better than the other. It really depends on what you're saying, you know, the type of judges they are, the tone, everything like that. So I'd be extremely cognizant of, you know, kind of of the judges and their disposition. And that way you would really be able to better determine, okay, well, what are they trying to do here? Does that make sense? Does that answer your question?
Absolutely, that's very helpful as well as frightening. I also had a question about the time commitment. I know it will be a lot, but I was wondering if you could give a realistic, maybe, I don't know, just like an average of how many hours a day, and if it's every day that you have to be dedicated to mooting when you're, I guess, starting a competition into it.
Okay, so personally for me, I'm not the type of person to like have a set schedule every day. I do work when I get the motivation and energy to do it, and I just ride that energy for however long it runs. So some days I might work like 3 or 4 or 5 hours even. Other days I might just work 2 hours. We all have lives, we all have things to do. I wouldn't say that it's so intense that it takes over your entire life, even though it does take over your life. There's when you're doing a moot competition, it will very often be on your mind. It will be in the back of your mind when you're doing other things. You might even feel guilty. Oh my gosh, I'm enjoying myself and my life, and I should be suffering trying to do research for this memorial. Don't feel guilty about that. That's a common feeling. I would not advise that you spend every waking moment on your memorial. It's just as important to spend time away as well. Because for me, when I take my mind off of work, I usually find inspiration in my surroundings. Sometimes I might go on Twitter, I might see a tweet about some kind of current event, and I'm inspired. And I was like, wait a minute, I didn't think about that. So I think it's important to have a bit of a balance. You'll have effectively a month. Well, a little less than a month to submit the memorial because it's due on the 3rd of June, I believe. Memorials, and it's 2. So obviously you're gonna have to make the extra effort to be able to get that done within these couple weeks. But it depends on how many people are in your team. If it's just you and one other person, you're gonna spend a bit more time. If it's you and 3 other people, you'll spend a little less time, but it really depends. But if I have to put a number for it, I would say, considering the time and everything, at least take some time out of the day every day. Probably 2 or 3. No, not personally. I would take like 5 hours like for 2 days, and the next day I might take like 2 hours. The next day I might not do anything at all. It varies, it depends. Sometimes in researching international law as well, you get stuck. And when you get stuck, it's important to step away for a minute, recalibrate, refocus, and go again. So I hope that that can answer your question. But is there anything you want to add, Nicholas?
I mean, there's not much I can add really. Is you summed it up really nicely there. I will say, like, as a cautionary tale, I'll use my story of the CCJ moot for a cautionary tale. So we had a decent amount of time to prepare for this memorial submission, skeleton arguments they were calling it for the competition, like a couple of months proper really to work on the skeletons. And then I see it and I'm like, yeah man, we had time dog. So I was doing it with, it was me and Nico, and Hiran was our researcher. Hiran Rampersad, former Law Society president, if you know him. But we, all that time, like, dog, all that time, just like, it just got squandered because we say, "Oh, you know what, it's so much time, we could put it off, we could put it off, I'll see about it tomorrow." And then tomorrow comes, and then you're working on other things. You have like different law society commitments. And that's not to scare you and say that, all right, well, don't do mooting because you're gonna have no time. No, do mooting, but be prepared for the major time sink that it is. And if you put it off till the last minute, you will be racing to the very last second to finish your memorial. So you guys have, like Alex said, like a month or so. Make sure you start from now, dog. Make sure you start from now. Because when we were doing that CCJ skeleton arguments, we made a mistake too. Because we thought, all right, well, every single moot competition that we've heard of, you have to submit 2 memorials. You have to submit one memorial on behalf of the applicants. You have to submit one on behalf of the respondents, not realizing that for the CCJ moot, we only had to submit a memorial on behalf of the defendants in the proceedings. And that was so heartbreaking because we did the applicant memorial first and we spent so much time on the applicant memorial. But at the end of the day, since we were able to get a finer appreciation of the applicant arguments, you could say it somewhat helped us to craft a stronger and more comprehensive defendant skeleton as well. So all that stuff goes into it. I can say for sure that it was like somewhat demoralizing to realize that you had spent so much time on a memorial that we weren't even going to use in the end, but I'd say it was still a very useful experience just in terms of just in terms of knowing what the applicants could have brought, because the other team like brought somewhat similar arguments to what we had written. Probably, yeah. Let me not say anything about Anton University. All right, back to the questions.
Yeah, so do we have any more questions at all? You can raise your hand, you can drop it in the chat. Aside from that, if you have any questions between now and the next session, you can feel free to reach out to me or Dr. Peru with your questions. Aside from that, as you all know, I have written the fact pattern. Do not message me to ask about about anything in the facts. I am not going to tell you. So I just have to put that disclaimer there one time. I'm not going to tell people things that are going to give them an unfair advantage over other teams. But everything, any advice that I am going to give will be given in those sessions that I spoke about before, as well as when I'm an advisor. Please do not reach out to me to ask me to specifically be your advisor. I will leave that up to a third party to decide which advisors will get assigned to which teams. That being said, I am going to create a WhatsApp group chat for the competitors, and I will send out links to join the chat. If you're in, for you all to join, you can ask any questions about the competition there as well. Even if you haven't signed up yet, you can still join the chat to kind of, test the waters, see what's going on, and just leave the chat if you're not gonna participate when you've decided to. But yes, that is it for this session. If no one has any further questions, Nicholas, do you have any final advice?
I just want to say, guys, thanks to Alex for inviting me first off. But like so importantly as well, just really consider getting into mooting. I'm somewhat pleased that the attendance throughout this remained constant. I think it even increased to 20 until just now. So that was good to see. But just mooting, like I said, it trains you in so many different facets, and it helps you to become a more holistic student, because you can see like what it really is like to think from the perspective of a lawyer. There's only so much that you can get out of IRAC problem questions, and only so much out of exam questions and research questions from your assignments, your coursework. So that when you're actually like getting into the brunt of oral advocacy, like written and oral advocacy, it really trains you in a way that you never get a fine appreciation of otherwise. So take the opportunity now while you still have it. Or if you want to hold off on it, know that there's future opportunities for you in mooting, even beyond the LLB. Like you could be in, there's always private universities hosting moot competitions that you could probably point to Alex or Dr. Peru, and they might be interested in talking about it with you. Or there's also, when you get to Hugh Wooding, if you take that path, if you go to law school, and there will always be future moots going forward. But take the time from now, like get the practice in, and trust me, it'll pay back in dividends.
Oh, and also one more thing that I want to make sure to get across to everyone. So usually when a team wins this competition, they are the ones who are selected to go on to do the bigger competitions that the faculty participates in. So because Nicholas and Nico won the competition, the internal competition, when they did it, they were selected to do the CCJ moot. When the faculty participates in moot competitions, they don't always make it an open call. Sometimes they, most times actually, they usually just go with the winners of the previous internal moot. That is always the first people that they ask. It's only if they decline that the faculty will look at other students to send to participate, considering that you all are going, likely going to be face-to-face. These MOOC competitions that the faculty participates in might be overseas, and the faculty might sponsor a trip for you to go represent them in these competitions overseas. So that is something that I personally would have loved to be a part of. So if you want to do something like that, I would recommend trying to win this competition now. So yeah, that is it. Me too. I wish I got to go as well. So yeah, I'm going to stop the recording now.